So we've got this really antiquated system. If we think about how much the field of medicine has evolved in the last 300 or 400 years and how much the legal system has evolved in that same time period, there's just no, it's just night and day, right, between the two systems. And so then we're looking to the court to come up with parenting plans when the legal system is just not the same societal development that we've seen in fields.
Yeah.
So we have to have litigation. It has to be available for the cases that need it. But yeah, most of the time, our clients are very clear that it's good for the kids if they can get along and if the kids can have memories around Halloween or year-end celebrations or whatever it is that really are consistent with what people hope for when those babies are born.
Yeah. Hi, I'm Rachel Green, Brooklyn-based divorce mediator and collaborative attorney, and this is my podcast, Keep the Kids in Mind. Join me as I chat with other industry professionals about everything from smoothly navigating your way through divorce to prenups, all the while keeping the kids in mind. Hello, welcome to Keep the Kids in Mind. I'm Rachel Green, your host, and I'm very pleased today to have Joanna Roth, a mediator in Seattle, right? Yes, that's where you are, to talk with her about one of my favorite conversation topics, which is mediation. Welcome, Joanna. Thanks for joining us.
Pleased to be here. Thank you.
So just to start, why don't you share with our audience how you came to do this work with families who are restructuring, moving to two households, and what drew you to this work?
I had a divorce about the time that I finished law school, and it went very badly. I had a very small child. My daughter was a toddler at the time. And I could not figure out how to make it happen in a way that respected the dignity of our family. So I had a guided tour of a litigated divorce. We had motions, we had forensic personality analysis, we had forensic investigation of parenting, we had a business valuation that was disputed. I was deposed.
Oh my gosh,
I had
so many complicated issues that can come up in a divorce. And there was a forensic evaluation, even though your daughter was so little.
Yeah. I was a brand new lawyer. I'd heard about mediation in law school. I read up about mediation, but I couldn't find the kind of mediation locally that I was reading about in my book. So the mediation that I got was settlement conferences led by litigators, guided by litigators, and it resulted in agreements that weren't very stable, that weren't very attuned to the developmental needs of my kid.
When you say you had settlement conferences, I actually never litigated. And so I guess my understanding of that is that it's kind of it's almost like an abbreviated trial kind of thing where you would meet and the clerk would say, or the judge would say, well, this is what I think you should do. Go in the room and talk about it. But it wasn't like eliciting your thoughts, ideas, needs, interests, your view for parenting your child. It wasn't, am I correct? Is that what you mean by a settlement conference?
Yes. So it was very much keyed to what a court would do based on what the court could observe. And I think there's a place for that. So I don't mean any of my remarks to sound belittling of litigation, but it didn't work for my daughter. It didn't work for me. I don't think it worked for my former spouse. My guess is that if we had him on camera and asked him, how did that go? He would not say it went well.
I have never heard of anybody come through the court process and say, that was great. We got a really good result. I was very happy with the process. I felt heard. I felt like it was tailored to our family. It was fair. I've never heard anybody come out of the court process feeling that way, unfortunately.
So at the end of all of that, I thought there's got to be a way that this can work better. And I was just starting my law practice at that point, and I took divorce cases, I took parenting cases, and what I had available to me at the time was litigation. So I became a family law litigator, and I thought, well, it's got to be better if I'm the one in the business suit and pumps, right?
Right,
And
because you've been through it and you at least had some ideas about how it should have gone.
yeah, and it turned out it was terrible as a litigator for me as well. I did not like the work. I had been the one standing next to my attorney when opposing counsel told the court that my only interest in parenting was receiving child support. And suddenly I was the one standing next to my client saying similar things. I don't
Yeah.
think I ever said that particular thing, but I'm not proud of what I did as a litigator. So fortunately, about that time, I came across collaborative law. And so that was really my entry point into doing divorce work in a way that matched better what I had hoped to do early on in my own divorce.
So just for our audience members who are not familiar with these different processes, in collaborative law, the spouses still have, or the parents still have their own attorneys, but we focus on their underlying needs and interests rather than legal arguments and positions. And we have meetings with the clients present and the attorneys present. And sometimes there can also be a family specialist, a psychologist who can help us advise on helping the children and understanding their developmental phases and their experience of the divorce. And there can also be a financial neutral if there are complex financial issues like a business valuation, which you said was in your divorce. But it would be one financial neutral instead of a battle of the experts. Um, and 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 if the case is not successful and breaks down, the attorneys have to withdraw. So it gets rid of the conflict of interest between the clients and the attorneys, because the attorneys can make so much money in litigation that in the back of their mind, I have certainly heard stories about attorneys who are not focusing on what their clients want, but instead more aware of how much money they'll make if it goes to a trial. So if the attorneys have to withdraw, they don't have that conflict. Is that kind of your consistent with your understanding and your experience of collaborative process as well?
Yeah, I think there might be slight regional differences. So
Mm-hmm.
typically, locally, we have the two attorneys, we have a coach for the couple, and frankly, for the team, we have a financial specialist. And we're particularly if there's a young kid, we'll typically have a child specialist. So I think we break that family specialist role into two pieces, but it's a very familiar process from your description.
Yeah. Yeah. I mean, the New York Collaborative Law, the New York Association of Collaborative Professionals, we've had, both the two coach model and a family specialist, or we've had like a one coach and family specialist in one person, but we've done both of those. So, yeah. And so the collaborative divorce was more consistent with what you were hoping, to try to find a better way to help families in transition.
Yeah. I think if I hadn't found collaborative law, we wouldn't be talking today because I would be teaching English as a second language at my local community college. I don't think I would have stuck around in the
Wouldn't have
field.
stayed in the law.
Yeah. Um, so I practiced in collaborative law principally for several years. I gradually gave up litigation altogether. I haven't litigated in probably over a dozen years at this point. And what I really, what's that?
Congratulations.
Thank you. Yeah, I'm very glad I was able to make that transition. And what I've really appreciated about the collaborative community is the interdisciplinary approach to divorce work and the ability to benefit from the expertise of financial colleagues and colleagues with a deep understanding of child development and kind of development over the lifespan as we work with different couples at different stages of life. And just the curiosity of the collaborative community that there is a great big world out there. There's only so much that we can know about. But if I know about this and you know about that, we can put our heads together and hopefully come up with a process that is as functional as possible for the clients and also efficient, right? So potentially a lot of professionals in the room. So we want to be able to coordinate in a really efficient way.
Right, right. That's true. Because people often have, trepidation about the cost when all those professionals are there. But if the case is run well, which is of course always our goal, we're having the professionals each in their own lanes and using them as needed. And it's more, I know a lot about child development and divorce, and I'm sure you do as well, but not as much as someone who's formally trained in psychology, a child psychologist. So it's more efficient to have them work on a parenting plan than you or I, you or me. No, it would be you or I. Anyway. And you also mediate.
So at this point, I work about 99% of the time as a mediator. So when we think about the specialization and generalization, I've ended up being much more of a generalist. So I'll usually work directly with the separating couple, and they'll consult with their attorneys. But most of the time, it's just me and the couple in the room. And I might say, well, here's some things you might want to run by your attorney. And I'll send out notes, and I might send that to the attorneys, but I might not, depending on how tightly I'm coordinating with the other professionals on the case. So it's quite possible they would get notes. They would say, go to their attorney and say, here are the things I'm supposed to talk about with you, and then they'll just come back. But it really depends on the needs of the family. And I think this relates back to something you were saying earlier, like what is the most efficient way to come up with a parenting plan? If the parents have about the same idea of how the kids are doing and their experience is the kids are fine and here's the schedule that's working for us, that's fine. I don't feel that I need to send them off to a child specialist or a child consultant. I really rely on their own sense of this is working well enough for us, and I'm willing to write that up into a parenting plan. There are some things that I feel I do need to cover with them because parenting does evolve.
I agree, 100%, because parents who are not separating don't have to bring experts into their home, unless there's a problem or unless they are having a conflict about something. But if they're on the same page, and I find that the majority of people who come to mediation, not all, but the majority, are not having conflicts about parenting. And in fact, that's one of the issues on which they're really still quite aligned. And they are coming to mediation to try to figure out a way to shield their children, help support their children, get them through this process with as little scarring, as possible, as few wounds as possible. And they're absolutely on the same page about that. And then we don't need an expert in that area because there's not really conflict.
I think that extends to finances as well. I do a lot of financial settlements, divorce mediators that I'm really good at dividing by two. And that's a lot of my financial expertise. There's more to it than that, but
Right.
that gets you a significant.
My joke is that divorce is one of the few areas where it's a disadvantage to have more money, because you might find yourself sucked into the litigation process because you can afford it. And people who have less money are much less likely to get pulled in that direction.
There's something very grounding about dividing 0 by 2. You kind of know how that's going to go.
Well, that's your expertise, dividing by 2. So
That's right. I stand by that.
And so how did you find your way to being mediator?
So when I joined my group of collaborative professionals and I got trained and I started working on cases, what came to me first was being an attorney consultant for mediated cases. So I met the mediators. They had more cases, they were smaller, those were more accessible to me as a newer collaborative professional. And I found I really liked that work and I really appreciated the work of the mediator in coordinating the case. And so I had that introduction into mediation. I definitely preferred being a consultant for mediated cases versus being a consultant on settlement conferences, which I did as a litigator. So I definitely liked that style of mediation. And I found it was also consistent with my personality. Um, my informal nickname for my practice is Ask a Hawaiian, because there's just that's just how I was raised. That there's just a focus on the whole, and it was this was one of the reasons that litigation just did not work for me. I could always imagine the other side, and so litigating was really painful, having to speak to only one side, and that just carried through. So when I was doing my work as a collaborative professional, it felt really natural to think about what was happening on the other side. I watched the mediator do it in real time. I thought, oh, that looks really good. And fortunately, I had a collaborative coach who was on a lot of my cases, and he and I were both thinking at the same time, wouldn't it be nice to work together? So he ended up bringing me in as a mediator on his cases where he had clients who were headed toward divorce. And I was kind of like a consultant, like a mediation slash mediator slash consultant on his case, where I could come into the room where he was doing his therapy work and talk about how to create a divorce. And so I worked with him extensively for about 3 years. I probably did a couple hundred cases with him. And that's really where I cut my teeth as a mediator. And thank goodness I had that support, because a lot of it was, bring Joanna into the room, and then he would remove Joanna's foot from Joanna's mouth as I figured out, how do I do this work? And I got some real-time feedback like, oh, that didn't work. But it was a very supportive environment, and I was able to recover from all those missteps. And I tried new missteps now. I try not to repeat the same old ones, always refining new missteps.
But
But
one thing I find about this work is that the clients will tell us when we make a mistake. I mean, when I loop what they're saying and I don't get it right, and I say, "Did I get that right?" And they go, "No, you don't understand this aspect of it." And I go, "Oh, thank you. Okay, so then there's this that I missed. Okay, yeah, now you got it." When I first started this work, I naively thought I would come in and tell them what to do, and they would say, "Oh, thank you, Rachel." And I very quickly learned that people want to make their own decisions.
yeah, I still have not found the couple that wants me to just hand their divorce to them. I keep trying. And they're like, nope, that's not it. Okay.
Well, it sounds like you found something that really resonated, and I feel that way about this work as well. And you're originally from Hawaii?
I'm Hawaiian. I grew up in Connecticut.
Oh, my daughter is with some friends in Hawaii right now. So I like that, that uh, characterization that you thinking of the whole. because I guess I feel that way. The litigation system really, like, it's ritualized war, and you basically are trying to destroy your adversary. And I just don't think that works with families. I mean, especially when there are children, you're always going to be connected through your child, through your children. You're always going to be that child's two parents,
Hmm.
for the rest of their lives. And for the rest of your life, you're going to be that parent. And, your children will not thank you for destroying their other parent.
No, one thing that I think about is so when I started, I was litigating, I was doing family law, I was also doing estate planning and probate. And so I had a front row seat in how dysfunction in the elder generation would just get transferred down to the kids. And so we would see probate disputes where the parents hadn't dealt with something. And so I can very credibly tell my clients the work that you're doing is for you, it's also for your kids. There's a legacy piece to how parents separate and how parents divorce. And it's a difficult developmental struggle to end a marriage, to separate lives in a way that maintains the family values, the family wish, that really deep wish for children to be okay.
Yeah. Even also, though, with couples who don't have children, they're always going to be part of each other's history. They're always going to have spent these years together. They'll always have had that experience that they at some point loved each other enough to, stand up and make a public commitment to each other. And then it didn't work out the way they hoped, but they're always going to be part of each other's history. And, for them as well, they don't have to keep the kids in mind, but they have to keep themselves in mind. And then sometimes they are children of divorce who experienced, being torn apart by their two parents. And I don't know if we can help them end their marriages, their relationships with dignity. I mean, that's my goal for all my clients.
Mm-hmm. Yeah, there's something about that. So I'm guessing we're about the same age. We're probably working with clients who are about the same age, and I think we're seeing a generational shift. So I do get a lot of clients who come in and say, I want to mediate because of how my parents fought in their divorce. I do not want that for me. I don't want it for my kids.
Right.
And
The legacy aspect way before the death. Right.
yeah. And so I think we do see a shift in how people think about divorce and about separation, even within the timeline of my own career. Most people, when I started my practice, whenever that was 20 years ago, it was hard for me to find the kind of mediation that I was reading about. I think it's very easy to find that kind of mediation now. Plenty of people who know about mediation and come to me specifically for mediation, whereas when I started my career, I tended to be the one telling people about mediation and saying
Right.
it was an option.
Yeah, same. I mean, when I started my practice, I was the only full-time mediator in Brooklyn. That is no longer true. There's probably 10 or 15 of us now, so it's grown a lot. Yeah, I think there is a shift in the generations in their awareness of it.
We actually lost a lot of mediators locally because they retired in the pandemic. I don't know
Oh,
if you saw the same thing.
no, not so much here.
Oh, okay. All right.
People
I'll send
transitioned.
my overflow your way.
Right, right. Um, and in your area, do you usually have joint meetings with the two partners?
That's the most common situation for me. So I'm not bound to it ideologically, but I do find that if it's tolerable for the clients, it's more efficient for
Yeah,
me.
right, right.
And it just, frankly, it just puts less pressure on me to have to remember every little thing
Mm-hmm.
that happens. Because, of course, I only meet with people an average of 5 times. So
Mm-hmm.
it's a very compact
Right.
process.
Streamlined. Yep. Same.
And they always know their situation better than I do.
So, I guess another thing about the mediation versus the court system, um, is that it has always surprised me how when you have separating partners come in and you talk to them and ask them kind of, open-ended questions. What do you want to talk about? Or what do you see as the things that we will need to talk about at some point in our process in order to resolve everything, and have a final, full settlement agreement that resolves all the issues between you. And how often there are things they want to talk about that wouldn't be discussed in court. Um, they're just like things that have come up, like they want to talk about what summer camp their kids should attend or school. Which, I mean, the judge, there's no law on whether they should, go to soccer camp or general camp, or whether they should join that intensive ballet or swim program, or not. And that's really parents' own visions for their children and their own values. And the courts, they don't have the time, they don't have the expertise, they don't have the interest in discussing those things. But in mediation, we can offer them a process that's really tailored to their own needs.
One thing that often comes up is that the court the court automatically assumes that these parents hate each other and
Yeah.
that it is the court's job to protect the children from the parents.
Hmm.
And it sounds like we both work in mediation where people select themselves to enter the process. And it's just a foundational notion for me that these are parents who want the best for their kids. They might view things differently, they might not agree, but neither one of them wants the kids to suffer. And I can rely on that base level of trust. And so the things that I focus on when we're talking about parenting are so different from what the court needs to know. Our parenting plans are structured around, is either parent unable to parent or need to be limited in their interactions with the kids? Are they going to come to the court or not when they need to pick a school, etc.? And very little of what we call a parenting plan has much to do with the children's developmental needs.
Hmm. But you're saying that in mediation, you can discuss the children's developmental needs. Or,
Yeah, I
yeah.
mean, there's only so much of it that I'm going to put in the public record as part of a parenting plan, but it's definitely part of how do they create a culture, a new family culture with the parents in separate households. What are they going to do when they need to coordinate? How are they going to manage those decisions? I'm not assuming, as the court has to, that every time they have a conversation, it's going to devolve into a fight.
Right, right. Yeah, and there are some families who have that situation, but they're not really, probably not the majority of families.
Well, I think that goes back to what we were talking about at the start, that litigation is there for a reason. One of the reasons I see parents, that I see couples in my mediation room, is because divorce is not optional. There is a default process that will happen um, after all hope has been exhausted, but there is a requirement for people to be able to get out of marriages. So I don't like litigation. I think I've covered that pretty thoroughly, but I do appreciate that it's part of the overall landscape that includes mediation.
Yeah. And um, in Seattle, do you prepare the settlement agreement or the separation agreement and also do the court filing for your clients, or what's the process in your area?
So I'm a little bit of an outlier on that locally. We have a very well-meaning volunteer committee with our state bar, with no mediators on it, certainly no family mediators on it. And they decided probably 12 years ago that attorneys who are mediators should not be preparing court documents. And they came up with this massive, it's kind of to my eye, kind of a medieval set of arguments for why that should be. And it's, if you ever need help going to sleep, you can look up the advisory opinion on mediation and preparation of documents. So we've got a lot of mediators who say, well, there's this advisory opinion from the bar that says we should not be preparing agreements. I'm like, well, I don't think it's actually that cut and dried. So I'm very comfortable preparing them. I often do have attorneys who are consulting on my cases. I always want my clients to feel confident in their agreements, that they say what they think they say, that they haven't missed any way to make the agreement more efficient or more balanced, but I don't require it. When you divide 0 by 2, it's still 0. You don't need an attorney to tell you that, but I just did in case. So I'm very comfortable preparing the documents. I draw the line at entering the agreements for clients. So the oddity with our local opinion is that it says, if you're the mediator, you can have your clients sign off so that you only represent one of the clients before the court in getting their documents filed. I think, well, that makes about 0 sense to me. I'm not going to put into a court filing that I represent one of my mediation clients. So I've toyed with the idea of writing into the document that I represent both, but I haven't actually done it. So that's a very long answer to a very simple question.
Well, we have the same tension and complexity here as well. And New Jersey, which is, a very close neighboring state to New York, to the New York City area, the mediators are not allowed to draft agreements. They just produce a summary of the terms agreed to in a document they call an MOU, a Memorandum of Understanding, and then find another attorney to draft. I see in my experience, there's a really big difference between an agreement that's drafted by an attorney for one of the parties versus an agreement drafted from a neutral perspective, such as I have as a mediator. In New York, mediators are permitted to draft agreements and also prepare and file court papers. And I do what it is advised in that long tome of the, it sounds like, of the memorandum in Washington, in that I kind of have a bifurcated process. So first I'm working with them as a mediator, and then I become the neutral drafting attorney. And then I have them sign a waiver to say, okay, Rachel's going to be listed as the attorney for the plaintiff in the court papers, but we're just doing that for a limited representation. I'm actually still working for, Amy and Alan or Amy and Andrea, whatever. I'm still working really for both of you, because to me, the court papers are really just ministerial. A paralegal could fill them out. They're just forms, and all the work that was needed to be done is in the agreement that we worked on together in mediation, and the court papers just reflect the terms of the agreement, and then I prepare and file papers, on behalf of one person on the papers, but in reality, I'm doing it for both of them. And they
Would you send me your form? I like that. I think this might be the piece that I've been missing.
Okay, yeah, I'll send that to you right when we finish the podcast.
Thank you.
And knock wood, so far, I guess 2 or 3 times I've had a judge who actually read the whole agreement and said, "Wait a second, you're listed as the mediator here in the agreement on page, 35, but in the court papers, you're listed as the attorney for the plaintiff." And then I have been able to just submit my paperwork and said, "No, we know what we're doing." And, that there's informed consent and waiver of any conflict, and the judges said, "Oh, okay." As long as
Hmm.
everybody knows what you're doing.
Yeah.
But, I find it interesting what your observation that the court process, there's an assumption that the parents are enemies and they're out to destroy each other, and that the best thing for the children would be to keep the parents as separated as possible to avoid conflict. Because, as we know, studies have shown that it's active conflict between the parents that causes the most stress, and scarring for the children. And we're trying to keep the kids in mind. Um, and so it's interesting that for the cases that do end up before a judge, the judge may see his or her role as trying to not have the parents encounter each other during the typical week in the schedule. Have the transitions happen at school. One parent drops off, the other parent picks up, so the parents don't have to see each other. But I work with many families who I've seen together on Saturday mornings on the soccer field, or with their kids together in the Halloween parade in the neighborhood. And I just love that when I see former clients together, with their kids. I think that's such a gift if the parents are able to be together with their child, and focused on the child, and in allowing the child to enjoy having both parents there, and
Yeah. And
able to do it. Yeah.
I think the court's in an impossible bind because all of the court procedures were designed around resolving property disputes, and there's the whole criminal procedure, and our courts locally didn't come up with a more modern set of family laws until the 1970s.
Hmm.
And so we've got this really antiquated system. If we think about how much the field of medicine has evolved in the last 300 or 400 years, and how much the legal system has evolved in that same time period, there's just it's just night and day, right, between the two systems. And so then we're looking to the court to come up with parenting plans when the legal system is just not the same societal development that we've seen in fields.
Yeah.
So we have to have litigation. It has to be available for the cases that need it. But yeah, most of the time, our clients are very clear that it's good for the kids if they can get along, and if the kids can have memories around Halloween or year-end celebrations or whatever it is that really are consistent with what people hope for when those babies are born.
Mm. Yeah. Well, it's been a pleasure talking to you, Joanna, about our practice area, where it's so, I can tell it's satisfying to you as it is to me, when we're able to help a couple navigate find the stepping stones through from their sadness, and disappointment that things turned out the way they did, but helping them to find the best way to get through this to the other side, and hopefully find more peace and happiness and contentment in their future lives, and help their kids to get through to the other side as well.
My pleasure. Have me back. This was really fun. I like
Yeah,
talking to you.
this is fun. I would love to have you back, and we can talk about cases, things that we've seen people do well, and things that we've seen people not do so well. So that would be a good topic as well.
That would
Um,
be
what are a few takeaways that you'd like our our audience to remember if you have it?
Oh, good question. So I really like this idea of legacy. So if our clients can have that hope of working with professionals who will be able to align with them on going through the divorce process in a way that is respectful and consistent with their own values, and who can help them get through the tricky bits so that they can get to that future where they can preserve what was precious about the relationship, as a significant life experience. If they've got kids, that they can have support in reaching that future where they can have a really nourishing family life for the kids over the lifespan.
Right, even if they're living in two households,
Mm-hmm.
that they can have a united love for the children, that still is there. And
Yeah.
then, what was the phrase that you had about ordinary heroism, was it?
Ordinary heroism. I think that is evidence of an ordinary heroism. So it is such, I mentioned toward the start the idea that separating is a really significant adult developmental task. And it is so tempting for people to think, well, if I work with an attorney who's going to fight for me in court, then I'll get the judge to agree with me. I'll get the settlement I want. I will do the parenting in a way that is so much better than my spouse, because look at them, they're a slob. The relationship falling apart is definitely their fault. And we all have, I think, those impulses at the start of a separation and at the start of a divorce. So it is heroic to say, well, even though I feel like that sometimes, at other times, I think my spouse actually tried their hardest, as did I. And my kids actually need both parents, and they need both parents to do their very best to maintain a loving, supportive set of households, just as we tried to in one household. And that requires parents to be really grown up at a time when they're under tremendous stress. That is such a hard thing to do. So when I see parents coming into my office and they say, we broke up a year ago and we've been doing things as best we can for a year, I'm like, wow, you have made it down a very long road and you've kept it together enough to end up in mediation. That's amazing.
Yeah.
Or they tell me, we decided to break up 2 months ago and we're immediately in mediation. Like, wow, that's a lot of figuring out to do in a short time. And you've come up with this together. Wow, that's amazing. And that's a kind of credit we just can't offer in court.
Mm.
Even if people start the court process with the best of intentions, the pressures are so intense and the support is so minimal that it's just extra super duper hard to maintain that kind of holistic, thoughtful mindset in litigation.
Yeah. And the court process, I think, is like throwing oil on the fire. It pits people against each other and makes them, cements them in their holding on to their anger, and instead of like trying to find a way to look forward to the future. But I just I love that phrase, the ordinary heroism. Yeah. So I always tell my clients they should pat themselves on the back, job well done that they came to mediation.
Absolutely.
Um,
And I'll pat you on the back. I
and
think
I'll
you're an
say the
awesome
same to you.
mediator. Oh, thank you. All right.
Thank
Okay.
you.
Okay.
Thanks so much, Joanna. And yes, let's try to plan a part two. Love that idea.
Okay.
All
I'm
right.
into it. All right. Thanks so much.
Okay. Thanks so much for listening to Keep the Kids in Mind. I'm Rachel Green, and this is Joanna Roth. We're signing off.